a very interesting report there today in the newspaper yesterday about an Irishman and his will and a significant amount of land in Mayo. Basically, this gentleman, he set up a very successful plant hire business in Australia, and he left a will or made a will leaving 320 acres of farmland in Ballycastle, County May, to his son. The problem arose, however, when he made a later will in Australia, which perhaps threatened to revoke the original will, leaving this land in Ballycastle, County Mayo, to his son. The judge decided that he did not intend, he was 75 when he died, the man James Brown, that he did not intend to revoke the will made in Ireland in 2000, dealing with his Irish assets only. And she admitted the Irish will then to probate, which means it's a valid will. And the later Australian will, which threatened to or apparently revoked this previous will, did not apply. The background is that this man originally from Newcastle or Ballycastle in County Mayo, emigrated to England when he was 18 years of age. He went to Australia then when he was 30. He originally worked as a machine driver. He did well. He developed a very successful plant and machinery hire business. He had a very strong connection with the lands, though, where he came from in Ballycastle in County Mayo, and as he became more wealthy and as travel from Australia became somewhat easier, he came back for summers, and he actually bought up a lot of land around the original homestead, with the result that he ended up with 320 acres of land, which he intended to leave to his son Tony. So he returned to Mayo every year, staying in a cottage he'd renovated and extended. He began buying the lands around this original homestead, this original cottage, from various other owners over the years. He took the old-fashioned view that the home place was always intended that it would go to his Tony, to his eldest and only son. So he involved Tony in farm work from a very young age, including rounding up cattle for testing, making silage, spending days on the bog, cutting turf and so on. He built up substantial assets in the States, or in Australia. In 1985 he made his first will, and he left all his lands, Irish and Australian, to his wife at the time, and to Tony and the other children they might have. He subsequently had 3 more children. Then in the year 2000, he made the Irish will, dealing only with his Irish assets and stating that it was complementary to any wills made or to be made in the future in Australia. Then in 2004, he made a further will in Australia, stating that he revoked all wills that were previously made. It was also stated, however, that will was intended to deal only with my estate in Australia and shall not affect any will made by me in respect of my Irish assets. The judge therefore found that the Australian will was in entirely generic terms, which on the face of it could be easily applied to property in either Ireland or Australia. That created a problem. However, the man's widow, who was the sole beneficiary of the Australian will, supported the view that the Mayo land should go to his son Tony. She stated that almost from the time of the son's birth, she knew and understood this. She said James was a traditional man, and it was his goal to directly hand down his homeland property from father to son, as had been done for generations before. She said that James made a separate Irish will to his Australian will to that effect to ensure that this would be the case. So the judge said the nub of the issue was whether the evidence showed that Mr. Brown, his long-standing intention, was it altered by the time he executed his Australian will, or put more simply, does it show that he changed his mind? And she said she was satisfied, the judge said she was satisfied on the balance of probabilities that he did not give any instructions one way or another to his Australian solicitor at any time in connection with his Irish estate or his Irish will. She found, therefore, it was quite clear that the revocation clause was inserted by mistake without thinking about the Irish estate and about its intention for the Irish estate. If Mr. Brown's intentions had changed, one would expect to see some outward expression of his change of heart, either by way of statements to his family or at the very least the instructions for his will. She said, there's no such evidence, and I'm satisfied that it would be contrary to the testator's intentions to find that the Irish will had been revoked. So the good news is there that the Irish will has been admitted to probate and the son will get the land. But it just goes to show you how easy it is to make a mess of things in making wills and revoking wills, and it becomes obviously more complex when there's a state in a foreign country, for example Australia, and perhaps real estate, land then in Ireland. Hope you find this video useful. If you do, would appreciate if you gave it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button down below. Also, if you're listening to this on by way of podcast, the Irish Law and Small Business podcast on Spotify or iTunes or YouTube or wherever, I'd appreciate if you left a review. Thanks a lot.